Hi, my name is Robert Chelle with Chelle Law, and my law firm assists veterinarians with employment contract issues. Today I'm going to talk about the main components in any kind of veterinary associate employment agreement. I'm not going to talk about independent contractor agreements today. I have a separate video on those. But let's kind of get into a quick breakdown of what to look for in any kind of employment contract for a veterinarian. So first, there will be the term, meaning how long it lasts. There'll be a section about termination, how you can terminate the contract, compensation, so is there a base or some kind of productivity component, the benefits associated with the position, and then the restrictive covenants. So let's kind of do a brief breakdown of each one. So first, the term of the agreement will be usually somewhere between 1 to 3 years. However, in any kind of employment contract, there needs to be a section in the termination part of the contract that's called without cause termination. And so what that means is the vet can terminate the contract at any time for any reason with a certain amount of notice to the other party. Now, the reason why it's so important that that clause is in the contract is if you enter into an employment arrangement with somebody, everyone expects it to be a slam dunk. It's going to be a perfect environment, great coworkers, great environment, heavy volume, good potential for compensation, all those things. But there's dozens of reasons why that may not be true. And so if you have, let's just say, a 3-year contract with no clause that states you can terminate the contract at any time, you're stuck for 3 years potentially, unless they're in breach of contract in some way. So you absolutely need that in the contract. Now, for a vet, a normal kind of without cause termination notice requirement is going to be somewhere between 30 to 90 days. For the most part, that assists in continuity of care and then also gives a little notice to the employer to find your replacement if needed. So you can't just give notice and leave the next day. You'll have to provide some kind of notice, but without cause termination is absolutely important. A contract can also be terminated for cause, meaning either party could be in breach of contract, and then either party will usually be given 15 to 30 days to fix the breach. That's called a cure period. And so let's just say the employer isn't paying the vet appropriately. The vet could say, hey, you're in breach of contract, you have 15 days to fix whatever the problem is, and if they don't fix it, that's when the vet could then terminate the contract immediately. So termination, next compensation. For most vets, it's either going to be base salary or a combination of some kind of base and net collections. So the pro-sal method is used a lot in the veterinary industry. I would Google that if you want some more details on that. I'm not going to get into that in this video. But one thing you definitely want to look into is if you are being compensated purely on production, or at least a majority on production, you need to make certain that the volume is there to get to the level of the, whatever you want to make on a yearly basis. I find really since COVID kind of began, veterinary practices have had a very difficult time reaching proper levels of staffing, which will then also or almost always, without the proper level of staffing, the vet simply can't be as efficient with their time as they normally would be. Therefore, they're seeing less patients, they're making less money. So you need to make certain that the employer guarantees that they will, staff appropriately and sufficiently to assist the vet in good practice. Now, as far as bonuses go, the payment and timing of those is important as well. If you're on some kind of net collection-based contract, you want to make certain that if the contract terminates, you still get all of those services that you've given out. Sometimes there's a lag, especially if there's insurance involved. Many contracts will state you only get paid through the date of termination and nothing else. Well, if you're on a net collections-based contract, money could come in 30, 60, 90 days after you leave. And then if there's language in there that states you won't be paid past the date of termination, you're losing out on all that money. You're essentially working for free for the last month or two. All right, next, benefits. So if you're working for an employer, you're going to get pretty standard employee benefits: health, vision, dental, disability, life, retirement. They'll pay for your vet license, DEA registration if necessary, continuing education, professional societies, associations. These are all things that an employer should pay for. Your malpractice insurance as well. Almost everyone uses the AVMA PLIT, the Professional Liability Insurance Trust, and it's a very, very low premium for vets compared to like a physician, for instance. So the employer still should pay for that, but not that big a deal for a vet. And then lastly, restrictive covenants, and sometimes for most people this is very important, and that's a restrictive covenant is something that the vet can't do either during or after the contract. I guess the restrictive covenants in most contracts would include a non-compete, a non-solicit, and a non-disparagement clause. So let's just talk about the non-compete briefly. So in most states, non-competes are enforceable. There's a handful of states that they aren't. Figure out if you're in one of those states. Assuming you are in a state where it is enforceable, there are three things to any non-compete. One is what the vet can't do, the scope, and then the temporal restriction, so how long it lasts, and then the geographic restriction, meaning what's the area the vet can't work within. So let's just say you're a general vet. It may say you can't work as a general veterinarian for 1 year and within 15 miles of your primary practice location, which would be a reasonable non-compete in most states. If you can do different types of specialties, maybe you worked in a hospital, then you want it to say you can't work within a hospital for 1 year within that period of time. You want to have options. So whatever you're doing specifically for that employer, you want to make that the scope of what you can't do, if that makes sense. Anything over a year I would consider unreasonable. Many places try to push it to 2, but anything beyond that certainly would be unlikely to be enforced by a court. So ideally 1 year. Now, a geographic restriction really depends upon where you are physically, meaning 5 miles in New York City could knock out hundreds of opportunities. 5 miles in rural Montana, you may have no other opportunities. So depending upon where you are, really kind of dictates whether a geographic limitation is reasonable or not. But let's just say a normal, fairly large city, somewhere between 5 to 20 miles from the primary practice location would be considered reasonable and enforceable. So anyway, that's just a brief breakdown of employment contracts for veterinarians. If you have any questions about your employment contract, independent contractor agreement, feel free to call my law firm at the phone number listed below in the description, or you can reach us through our website, ChelleLaw.com. If you thought this video was helpful, please like, subscribe to the channel. We release videos every single day. All right, appreciate it. Thanks.